Incorporation is the idea that the provisions of the Bill of Rights can be applied against state governments, not just against the federal government. The basic idea here is that the Bill of Rights itself applies only to the federal government. So you look at the very first words of the First Amendment: Congress shall make no law. And in a 1833 case, Barron versus Baltimore, the Supreme Court said that's the case for all of the Bill of Rights, that they apply only to federal laws, not to state laws. So states could, under the federal Constitution, states could establish religions, states could pass laws that abridge free speech, states could do sort of all kinds of things like that. Now, of course, in many states, they had their own state constitutional Bill of Rights that would forbid those things. But that would be a matter of state law for state courts to decide. As far as the federal Constitution was concerned, the Bill of Rights applied only to the federal government. One of the principal purposes of Section 1 of the 14th Amendment was to what's called incorporate the Bill of Rights against the states, which is to say to make those guarantees efficacious against not just the federal government, but the state government as well. So the idea is that now, after the passage of the 14th Amendment, not only can the federal government not abridge the right of free speech, but no state government can abridge the right of free speech either. Now, I think a lot of scholars think that the provision of the 14th Amendment that was meant to accomplish this purpose was the Privileges or Immunities Clause. As I mentioned, that was basically gutted by the Supreme Court in the slaughterhouse cases. So when the Supreme Court did later get around to incorporating rights against the states, it chose to go with the Due Process Clause instead. That's probably not all that significant a difference. It's probably led to more or less the same outcome either way.
What the court has said is that the Due Process Clause of the 14th Amendment, right, that says that you won't be deprived of your life, liberty, or property by any state without due process of law, that includes within it a concept of ordered liberty, a concept of the rights that everyone has, and that among those rights and among that ordered liberty are the Bill of Rights. And so the Bill of Rights get incorporated against the states through the Due Process Clause of the 14th Amendment, right? So the right to free speech is protected against the states. You have a right to free speech protected against states, not because you have a First Amendment right, that's how we usually talk about it, you have a First Amendment right to free speech, but because the First Amendment right to free speech is part of due process. It's part of what it means for you to receive due process.
Bill of Rights cases are actually, incorporation cases are actually 14th Amendment cases. Often we talk about something as a First Amendment case when in fact it's not. So all of the cases where a state infringes someone's right to freedom of speech are not technically First Amendment cases. They're technically 14th Amendment cases because they're the incorporation of the First Amendment against the states. Because states make so many more laws than the federal government, and that was especially true the further back in our history you go, the court had not developed a huge amount of rights jurisprudence before incorporation, because the federal government just didn't pass that many laws that operated directly on individuals, so there wasn't that much of an opportunity to develop a rights jurisprudence. Now, that's not to say there was no opportunity. Technically, Dred Scott is a rights case. It's about Sanford's right to bring his slave into the federal territories. But there weren't that many rights cases before incorporation. So most of what we think of as First Amendment case law, most of what we think of as Fourth Amendment case law, much of what we think of as Fifth Amendment case law are developed as a result of incorporation. And many of them are 14th Amendment cases, but even the ones that do apply to the federal government, a lot of that doctrinal development occurs after incorporation and is partly driven by the logic of incorporation.
As the Supreme Court starts to incorporate the Bill of Rights against the states, it aggrandizes its own power yet again. So in the past, the federal government has all this power, and the Supreme Court has a lot of power to protect individuals from federal intrusions. But what happens now is the Supreme Court becomes a protector of individuals against the states, too. You don't get Brown versus Board of Education. You don't get Roe v. Wade. You don't get all the cases, many of the cases that we know as the most important, most famous Supreme Court cases, unless you get incorporation. Those cases don't happen because the Supreme Court isn't protecting individuals from their own states. It's only protecting them from the federal government until incorporation.